This morning at exactly 10:30 a.m. Eastern Time, the Supreme Court of the United States made a short but powerful ruling. They denied an application in a major legal case. All 9 justices agreed, and not one of them disagreed or wrote a separate opinion. The entire ruling was just 2 words: application denied. That one sentence ended months of legal fighting. And this ruling came exactly 72 hours after Melania Trump's lawyers submitted a special agreement to federal prosecutors. In that agreement, she outlined the evidence she was willing to give in exchange for possible immunity from prosecution. 2 huge legal events happened just 3 days apart, and the timing suggests they were closely connected. Before anyone dismisses this as gossip or exaggerated news, the information being discussed comes from court filings, official agreements, and Supreme Court orders. These are all public records, not anonymous tips or secret leaks. Anyone can look them up and verify them. Here is what has now become legally official. If you want updates on this developing case and more breaking legal analysis like this, hit that subscribe button right now and turn on notifications. Don't miss what happens next. Melania Trump has given up her spousal privilege. Spousal privilege is a legal protection that normally stops prosecutors from making a husband or wife testify against each other. She gave it up on her own, willingly. The evidence she is presenting falls into 3 main areas. The first is financial documents that reportedly show knowledge about dishonest property valuations. The second is communications, including discussions about property values and loan paperwork. The third is her own testimony as a witness, which will back up what accountants and bankers have already told a grand jury under oath. Because the Supreme Court rejected the final appeal, there are no more legal options left to stop this. There are no more appeals to file, no more ways to delay, and no more procedural tricks available. The grand jury can now hear her testimony within days. On top of all that, her former husband's confirmation hearing as a cabinet nominee is set for early March, just about 6 weeks away. Here's exactly how things unfolded over those 72 hours because the order of events was not random. On Monday afternoon at 2 p.m. Eastern, Melania Trump's lawyer submitted a document to the special counsel's office. This document is called a proffer agreement. In simple terms, a professor is like a preview. The witness tells prosecutors what they know, what they are willing to say under oath, and what evidence they can hand over. In return, prosecutors consider giving the witness immunity, which means protection from being charged based on that testimony. This happens regularly in federal cases. What makes this one extraordinary is who the witness is and what she is offering. On Tuesday afternoon at 2 p.m. Eastern, exactly 24 hours after the proffer was submitted, the defendant's legal team filed an emergency appeal to the Supreme Court. This just got even crazier. What's going through your mind? Comment your honest take. Is this the turning point we've been waiting for? I'm replying to as many as I can. Let's talk about it together. They asked the court to block her testimony before the grand jury could hear it. Their argument was that testimony from a spouse violates marital privacy protections under the Fifth Amendment. Filing an emergency appeal in just 24 hours is very fast. Most of these appeals take weeks to put together. The fact that this one was ready so quickly strongly suggests the defense team already knew this was coming and had been preparing in advance. On Wednesday morning, the Supreme Court officially received the appeal. They gave it a case number and scheduled it for review. But here is the important detail. They did not issue a stay. A stay would mean everything stops while the court thinks it over. No, stay means the legal process keeps moving forward while the court considers the issue. This silence from the court matters a great deal. When the Supreme Court issues an immediate stay, it usually means the justices think the argument has some merit. When they let things continue without a stay, it usually means they have doubts about the argument. Then this morning, Thursday, at 10:30 a.m., the Supreme Court gave its final answer, one sentence, application denied. No dissents from any justice. Justice Thomas did not disagree. Justice Allo did not disagree. Justices Gorsuch, Kavanaugh, and Barrett, all of whom were appointed by Trump, did not disagree either. It was a unanimous rejection. When the court writes an opinion, even a brief one, it means the legal question needed some explanation. When they issue a single sentence with no disagreements at all, it means the appeal was not even worth discussing. In over 30 years of following legal cases, this kind of total rejection has only been seen a handful of times each time. It meant the legal argument was so weak it did not deserve the court's time to explain why it failed. So that is the full 7-hour sequence. The proffer was filed Monday. The emergency appeal was filed Tuesday. The court received the appeal but did not pause anything on Wednesday, and the application was denied on Thursday. Now, here is what is actually inside the proper agreement, because the evidence she is offering is much more serious than the headlines suggest. The agreement describes 3 categories of evidence. The first category involves financial documents showing she was aware of dishonest property valuations. She signed joint tax returns from 2014 to 2020. That is 6 years of tax filings where both spouses sign under penalty of perjury, swearing the financial information is correct. These tax returns depend heavily on how assets are valued, meaning what properties are worth, how much income they produce, and what tax deductions apply. If those property values were made to look higher when shown to banks to get loans, but then made to look lower when reported to tax authorities to pay less in taxes, that is both bank fraud and tax fraud. And a signature on a joint return creates legal risk for both people who signed. The proffer also states she was present at meetings with accountants where asset values were talked about. She even asked questions about how properties were being reported. All of this is backed up by emails that prosecutors already have. The second category involves communications. This includes text messages between her and the defendant discussing property values before meetings with lenders. It also includes emails with accountants where she questioned the differences between what was being told to banks and what was reported to tax authorities. On top of that, there are recorded phone conversations where specific property values were discussed in connection with loan applications. In federal cases, if she recorded conversations in a way that followed consent laws, those recordings can be used as evidence. If she is offering them in a proffer, prosecutors have already carefully checked to make sure the recordings are real. The third category is witness corroboration. She can confirm what accountants already told the grand jury. She can back up what bankers said under oath. She can support what property appraisers said about being pressured to make property values look higher than they really were. In federal cases, corroboration is extremely important. If one witness says they were in a meeting where dishonest valuations were discussed, that is strong. If a second witness says they were in that same meeting and confirms what was said, that is stronger. If a third witness produces documents from that same meeting showing the dishonest values, that creates a pattern of evidence that becomes very hard for any defense to overcome. Here is the biggest legal shock buried inside this proffer. She is waiving spousal privilege. In most cases, a spouse cannot be forced to testify against their partner. This protection exists because the law recognizes that marriage requires trust, and the legal system should not destroy that trust by forcing testimony. But spousal privilege can be given up voluntarily. Her proper agreement specifically states that privilege is waived for all matters covered in the agreement. This is not prosecutors forcing her to cooperate. This is her choosing to cooperate on her own. Spousal cooperation has been seen before in organized crime cases, where wives of mob figures testified to protect themselves. It has been seen in corporate fraud cases where spouses of business executives cooperated after realizing they shared legal risk. But this is the first time at this level where the defendant once held the highest office in the country that a spouse has come forward with financial records, communications, and direct testimony. The defendant's emergency appeal to the Supreme Court made three main legal arguments, and all three failed. Loving how this case keeps unfolding. What's your reaction right now? Drop a comment. Agree, disagree, shocked, or something else. Your thoughts always make the conversation better. Hit that comment button. The first argument was that spousal testimony violates marital privacy protections under the Fifth Amendment, but there are 150 years of Supreme Court rulings saying that spousal privilege can be voluntarily waived. The key case is Trammell versus United States from 1980, which ruled that the witness spouse is the one who controls the privilege. That means the decision to testify belongs to the witness, not the defendant. If the witness chooses to waive privilege and testify, the defendant cannot stop it. That ruling has never been overturned, and every federal circuit court in the country follows it. So this argument had no legal basis at all. The second argument was that the proper agreement was obtained through force, threats, or pressure from prosecutors, making the testimony involuntary. But the filing includes a sworn statement from her own attorney saying that she was the one who reached out to the special counsel's office first. Her lawyer initiated the contact, proposed the cooperation, and negotiated the terms. No subpoena was issued and no threats were made. The proper was entirely her decision. Federal courts have a clear standard for determining whether cooperation is voluntary. Was the witness threatened with charges if they did not cooperate? Was their own potential criminal liability used to pressure them? If the answer to both is no, and the witness came to prosecutors on their own, the cooperation is voluntary, the sworn statement from her lawyer completely destroyed the claim of coercion. The third argument was that allowing this testimony would set a dangerous precedent that would destroy marital privacy in all future cases, but that precedent already exists. Spouses regularly testify in federal cases when they choose to do so. The Trammell case settled this question in 1980. What the defense was really asking for was a special exception based on who the defendant is. The Supreme Court does not create exceptions based on a person's identity. The law applies equally to everyone. So when the court issued its 1S sentence rejection with 0 disagreements, it sent a clear message. The arguments were not just weak, they were considered frivolous. To succeed with an emergency appeal to the Supreme Court, you must show that serious and irreversible harm will happen and that you are likely to win on the legal merits. This appeal showed neither. Having testimony heard is simply how the justice system works, and winning on the merits would have required overturning the Trammell ruling, which no justice was willing to do. With the Supreme Court appeal denied, the grand jury can now hear her testimony within days. The grand jury in this case meets on Tuesdays and Thursdays, which is standard practice in the Southern District of New York, where the case is being handled. If prosecutors are ready, and the proffer suggests they are, she could appear before the grand jury within the next 7 days, possibly as early as the coming Tuesday. Once her testimony is finished, prosecutors face a strategic choice between two options. The first option is to use her testimony to make the existing charges stronger. The current indictment includes 34 counts of falsifying business records and bank fraud. Her testimony about signing joint tax returns, attending meetings with accountants, and backing up other witnesses would strengthen the case on the charges that have already been filed. The second option is to seek what is called a superseding indictment, which would add new charges based on the new evidence she provides. One thing to watch closely is a conversation from March 2020 that she mentions in the proffer. She says she was present during a phone call between the defendant and a banker where property values were discussed before a loan application. If that call included both of them making false statements together with him saying one thing and her confirming it while both knew it was not true, that is conspiracy to commit bank fraud. Conspiracy is a separate crime from fraud itself. It requires an agreement between two or more people to commit any legal act, plus at least one concrete step toward carrying it out. A phone call where both people knowingly lie to a bank is the agreement. Submitting the loan application is the concrete step. If prosecutors believe they can prove conspiracy through her testimony, they will pursue additional charges. A superseding indictment would add new counts and could significantly increase the defendant's legal exposure. The trial is currently scheduled for September 16th, which is 28 weeks away. With the Supreme Court appeal denied, there are no more delay tactics available, no more emergency motions to block evidence, and no more privilege claims to argue over. That trial date will hold. This case sets three precedents that could affect federal prosecutions for decades to come. The first precedent is spousal cooperation at the highest levels of power. Spouses have cooperated in organized crime cases before. In the 1980s, prosecutors relied on wives testifying against husbands in mob cases. Sammy Gravano's wife cooperated, and so did Henry Hill's wife in the case that inspired the movie Goodfellas. Spouses have also cooperated in corporate fraud cases. During the Enron prosecutions, multiple executive spouses testified, but no one has ever seen this at the presidential level, with the spouse of someone who held the highest office coming forward with financial records, communications, and testimony that directly implicates them in federal crimes. This changes the game for future investigations. If a federal prosecutor is building a case against a powerful official and knows the spouse has shared legal exposure because they signed documents or attended meetings, they now have the Supreme Court precedent confirming that spousal privilege cannot block voluntary cooperation. The second precedent is that the Supreme Court's fast response sends a message that privilege claims will not be allowed to delay federal cases. The one-sentence rejection with 0 dissents just established a standard. When spousal privilege is voluntarily waived, emergency appeals based on marital privacy will not succeed. Courts will not let delay tactics be disguised as constitutional arguments. This matters for every future white-collar crime case where spouses share financial exposure. Defense lawyers now know that privilege claims will not work as a strategy for buying time when the witness has chosen to cooperate. The third precedent is that accountability applies no matter how wealthy or powerful someone is. For decades, wealthy defendants have used procedural tactics to stretch cases out with endless appeals, privilege claims, and emergency motions, hoping to outlast prosecutors or wait for political changes. This case shows the system can still function when courts act decisively. The judge maintained a strict schedule. The Supreme Court unanimously rejected delay tactics. The grand jury process continued without interruption. The court said no. The judge said no. The law was applied equally, and the system worked because the institutions held firm. Over the next 30 days, 3 specific things to watch will reveal the prosecution strategy. The first is grand jury activity. If new witnesses are subpoenaed within 2 weeks, it means prosecutors are building toward new charges. The pattern of new witnesses and subpoenas will tell you everything, because more witnesses means more counts. The second is the defense team's response. They will almost certainly file a motion to have her testimony thrown out, which is standard, but what matters is what they focus on. If they attack the recordings, it means the recordings are damaging. If they attack her credibility, it means the documents are strong. Defense motions reveal what the prosecution's strongest evidence actually is. The third thing to watch is whether the immunity agreement gets finalized. The proffer is only the first step. Full immunity requires a signed cooperation agreement, which is a formal contract that spells out exactly what testimony is required and what protections are given in return. When that document is filed, it will show the full terms, whether she gets full immunity, partial immunity, or what is called use immunity, which only protects the testimony itself from being used against her. The Supreme Court did not write an opinion because the law was already settled. Spousal privilege can be waived. Evidence will be heard. No one is above the law, not because of wealth, not because of privilege, and not through endless appeals. The system worked because the court followed established precedent.